All right, part one, 111, 4, evidence discovery. Subpart 8, general rules. Evidence 1, admissibility. 2, official records. 3, admissibility of business records. 4, documents of board files. 5, records and other board proceedings. 6, official notes of the corroborative materials. 7, exhibits. Subpart B, discovery. 21, applicability, general provisions. 22, depositions. 23, deposition local officers at the time of the fees and the absence of the disqualification. 24, disposition procedures. Deposition procedures. 25, effective errors or irregularities in the depositions. 26, written interrogatories to the parties. 27, requests of admissions. 28, depositions, requests of admission for the written interrogatories in response to thereto, inclusion of the record. 29, supplemental or response. 30, production of the documents of the record of the entry upon landing and inspection. Other purpose of the 31, failure to respond to discovery. Subpart A, general rules of evidence. Admissibility. Evidence 1114.1, admissibility. Evidence for the sufficiently reliable probative to support the decision under provision of the Administrative Procedure Act, which would be admissible under the general statute of the United States, under the rules of the evidence governing the proceeding of an evidence not involving trial by a jury of the courts of the United States, admissible for the hearing of the board from before the board with the rules of the evidence apply with the proceeding of the end of the necessary to provide that the evidence will be conventionally, inexpensively, and speedily produced while preserving the substantial rights of the parties in 111.14.2, official records. Official record entry thereof would be admissible for any of the purpose of the evidence for the official of the publication thereof, the copy of the test of the officer having the legal custody of the record of the and or by deputy of accompanying with a certificate such of the officer has the custody of the officer for the which of the record is kept within the United States or within the territory of insular possession subjective to the dominion of the United States. The certificate may be made with the judge of the court of the record of the district or political subdivision which of the record is kept authenticated by the seal of the court or made by any of the public officer having the seal of the officer have the official duties of the district. Official duties of the district or political subdivision in which the record has kept the authenticated seal of his office. If the office in which the record is kept at the foreign state of the or the country of the certificate may be within the secretary of the embassy or legatation, consul, general counsel, vice consul, with a consul agent by officer of the foreign service of the United States, with the citizen of the foreign state of the country in which the record is kept, the authenticated by the seal of the officer of the written statement, the sign of the officer having custody of the official record of his deputy. After the diligent search of the no record entry for the specified with the tender that is found with the exist for the records of the officer of the company with the certificate as approved of admissible evidence that the record of the officer for the contained with no such record or entry of the section does not prevent the proof of the official records of the entry of the lack of the entry there are official notes thereof that method authorized by the applicant statute by the rules of the evidence. 1114 3. Admissible of business records. Any written record of whether in the form of the entry of the book of the otherwise made a memorandum of the record, if any of the transaction occurring for the event for the admissible with the evidence thereof the period that it was made with the regular course of the business that was regular course of the business to make stuff of the memorandum of the record at the time such record that made within the reasonable time thereafter. 1114.4. A document of the board filed from the party officer of the evidence of the material contained with the report other documents upon the public inspection into the file of the board in such report other document needs not to be made available at the hearing. 1114.5. The records and other board proceedings. Any portion of the record before the board in proceeding other than proceedings at the issue for the evidence of the true copy will present for the record. 1114.6. Official notes for this corroborative material of the board hearing officer made with the take of the notice official record of the record of the board proceedings other material of the otherwise subject for the special rules governing the admissibility of the regardless for the complying with the full technical provisions of such rule for the admissibility of the evidence for the purpose of the corroborative of the testimony of the presented with the evaluate the credibility of the testimony allegations made and proceed with the public interest in any otherwise adequately represented by the counsel capable of fully complying with such rules. 1114.7. Exhibits. Whenever practicable, sheets of each of the exhibits aligned with each of the sheet with the shall be numbered with the exhibit of the consist of 5 or more sheets of the first of the sheet with the title page should be confined with a brief statement of the exhibit that purports to show that the reference of the sheet with the illustrator of the typical examples of the contained therein, but the exhibit should be verified identified with the number 11 the short short title, which readily distinct it from other exhibited officers of the same party. Evidence desirable whenever the practicability evidence shall be consent and tables whenever the practicability, especially with the pursuit of the which the likelihood of the many of the documents will be offered. All of the documents procedure produced will be in a single witness should be assembled and bound together. The suitability to arrange an index such that they may be identified and offered with one exhibit that should not be argumentative and should be limited with statements of the facts and be relevant material to the issue, which can be better shown in the form of the oral testimony. All right, subpart B, the discovery. Or 11.14.21, applicability of the general provisions. Whenever the discovery available, the parties may be obtained with the discovery under this subpart regarding any of the matter not privileged with relevant to the subject matter involved with the prior proceeding other than the informal proceeding with the purpose of the subject of the informal proceedings are those not required to determine on the record of the hearing and include with the informal complaints of the L proceedings assigned with the initial disposition of the employee boards under 10.11.5. It is not grounded with the objection of the information sought of the admissible as evidence of the information sought appears responsible for the calculation to leave the discovery of admissible evidence. In the case using the simplified standard of the three benchmark method, the number of the discovery requests of either party can submit is limited and set forth in 11.14.22, 11.14.26, and 11.14.30. Absent advance authorization of the board how the discovery is obtained, all discovery procedures may be used with the parties without filing out the petition and obtained with the prior board approval. All right, your protective conditions. Upon motion of any of the part of the person from whom the discovery is sought, or by any of the person responsible for the data information for the material sought for the discovered for good cause shown that any of the order justice requires may be entered to protect the party of the person of the announcements and embarrassment and oppression of the undue burden and expense to prevent the raising of the issue of the untimely and appropriate for the proceeding with the relief of the protective order that may include one or more of the following: the discovery not to have, but the discovery may be have the only to specify the term of the conditions, including the designation, the time, and the place. 3. The discovery may be have only of the such the terms and conditions of the board may impose with the ensure of the financial responsibility identified with the party of the person against the discovery of the coverage with the reasonable expense for the incur for the discovery that may be to have the only with the method of the other than the selective of the parties seeking the discovery. Certain matters will not be inquired into. The scope of the discovery with limited with a certain manner of the discovery is conducted with no more than one present, except for the person designated with the protective order. The deposition after being with the shield of the openly only order of the board of the trade secret or of the confidential research, the development of the commercial information not disclosed or disclosed of the designated way, but the party of the simultaneously filed with the special of the documents information and closed with the seal of the envelope to be open only with the direction of the order of the board with the motion and protective order of the deny of the whole and part of the board may or in such term of the condition of the deemed just as enter with the order with the requiring any of the part person that provide with the discover the protective order under the paragraph that may only with the be solved after the conjunction with an effort by any of the party retain the relief under 11.14.24, 26, and 31. Sequence over the time of the discovery. Lift the board open for the motion subject to the requirement of Title 49 CFR 11.11.2 and 11.11.5F. Stand alone copy with the conveyances of the party of the witness of the entry of the justice of the orders of the wise method of the discovery may be within the sequence of the fact of the party of the conducting the discovery whether the disposition otherwise should not operate to delay with any of the parties. Discovery stipulation regarding the discovery unless otherwise ordered with the written stipulation entered into by all the parties of the file with the board or plot may provide the disposition to take up before any of the party or any person at any time of the plea with insufficient notice emanating there, whether taken may be even like other dispositions, modify the procedures by the rules of the other method of discovery. Surface of the discovery of the materials unless otherwise ordered by the board within subject with the requirement of the Title 49 CFR 11.11.2 of F 11.11.5 F at the standing alone with the cases cost case of the disposition interrogatories requests of the documents requests of the admission and the answers responded thereto but they shall be served only on the other counsel of the party but they shall not submit file with the board any such material for the portion thereof that shall be appended to the appropriate pleading whenever you the support reply with this motion when you the evidence submission. 11.14.22 the deposition proof of the testimony of the person included with the party may be taken with the deposition with the oral examination request of the party requesting with the take with the deposition perpetuate the testimony of the one shall notify all of the parties of the proceeding with the person sought to be deposed and she set forth the name and the address of the witness of the place wherever the time and the name of the officer before whom the case of the region with the deposition will be taken. Limitation under some of the simplified standards in any case of the three benchmark with the methodology each of the parties limited to the one deposition absent advance of the authorization from the board. 11.14.23, the deposition location officer for the time and the fee of the absent disqualification. When the deposition should be taken unless otherwise ordered with agreed to town stipulation, the deposition should be taken into the city of the municipality where the deponent is located. Officer may before whom taken within the United States within the territory and solitary possession subject for the dominion of the United States with the deposition should be taken before an officer authorized with administrative rules and the laws of the United States or of place for the examination held within foreign country. The deposition may be taken the officer of the person designated with the board agree with the party for the stipulation with the writing and then filed within the board. Fee for the witness for the deposition of the take of the person with the rule for the officer of taking someone unless they have been employed by the board shall be entitled to the same and the fee paid for the like with the service of the courts of the United States, which the fee should be paid by the party with which in the instance of the deposition is taken. The failure to attend with the service of the sustaining expenses within the party with the file of the position discovered the failure to attend with the proceed with the taking of the deposition of the other party attended in person by the representative of the pursuant the anointing of the order of the board granting the discovery of the board may be the order of the part of the file of the position or to such other party with a reasonable expense for the incurred by him his and representative attending and include with the reasonable attorney fees. If the party who filed the petition discovered he failed to serve the subpoena for the witness of the witnesses because of the social failure does not attend with anything with the party attend with the person with the representative because he is expected for the disposition of the witness to be taken from the board who may order the party with the file of the petition to pay for themselves of the other party with the reasonable expense of the insured with by him with the representative is and so with attending and inclusive representative reasonable attorney's fee. The disqualification of their interest of the noted position should be taken with the before a person with the relative of the employee of the representative with the council, any of the parties, or relatively with the employee of such representative of the council is financially interested in the proceeding. 11.14.24, the deposition proceed with the examination and the examination of the cross-examination of the witness should be proceeded with the permitted with the hearing when they shall be limited to subject matter the specified with the order of the granting of the discovery the objections made at the time of the examination to the qualification of the officer of taking the deposition for the manner of the taking and the evidence presented with it or to the any of the party any of their objection proceedings should be noted for the officer upon with the deposition of the evidence for the objection should be taken and subject with the objections in lieu of the participation of the oral examination party for the serve of the written question for the seal of the envelope of the party for the taking the disposition shall transmit them to the officer for the show open and seal the envelope propound with the question for the witness and the record for the answer for the verbatim. Use of the deposition hearing with any of the part of all the depositions of the evidence as far as the admissible under the rules of the evidence may be used against any of the party who have the representative of the presented with the taking of the deposition who had to do the notes of the airboard in accordance with any of the following provisions. Any deposition may use any of the part of the purpose of contradictory impeaching of the testimony of the deponent of the witness. The deposition of the part of anyone who at the time of the taking of the deposition of the officer, the director, of the management, the agent, of the or the person designated to testify on the behalf of the public, of the private, the corporation, partnership, the association, governmental agency, other than the board, except in those of the instance with the board itself, as a party to the proceeding, which of the party may be used the adversary party for any of the purpose of deposition of the witnesses, whether or not a party with may be used any of the party within person of the presiding officer board finds that the witness is dead, of the witness for the greater of the distance of the 100 miles over the place for the hearing of the house over the United States, unless it appear for the absence of the witness was procured by the party offering the deposition of the witness is unable to attend the testifying with recover the age of the illness and infirmity of the imprisonment. The party of the offering of the deposition has been able to procure the attendance of the witness by subpoena or upon application of the notice of the such examination over the circumstances exhibited to make the desirable interest of the justice of the with due regard over the importance of the presentation of testimony of the witness or over the public hearing to allow the deposition to be used only with the part of the deposition offered for the evidence of the part of the verse party may require the introduce any of the part of which all of the fairness of the consider the part of the introducer any part of the introduced or introduced any other parts of the substitution of the party that does not affect the right of the deposition previously taken affecting the effective taking and the use of the deposition party should not take with the deem of the make of the person but has his own witness or any of the purpose of the taking of his deposition any of the introduction evidence for the deposition any of the part of thereof any purpose of the other than the contradiction impeachment of the deponent that makes any of the deponent with the witness of the party of the introducing the deposition but this should not apply to the only use of the diversity part of the deposition under the paragraph B2 of the section of the hearing of the party that may rebut and any of the relevant evidence obtained with the deposition whether they introduced by him or by another party. Measure for the protect. Any time during the taking of the deposition motion for the part of the deponent with the showing the examination to be conducted by bad faith of them in such a manner unreasonably annoy, embarrass, and impress with the deposition of the party of the board may order the officer for the conduct with the examination to the case of the C4 for the taking of the deposition, make a limited the scope of the manner of the taking of the deposition as provided with 111421C. In the order of the made determining examination, it should be resumed thereafter only if it's in some so ordered, depending upon the ejection of the party of the deponent of the taking of the deposition should be suspended for the time necessary to take of the motion of the order. Recordation. The officer before the deposition of the take of the shall observe the provision 1113.6 for the respecting the appearances and the typographical specification shall be put with the witness under of the oath and shall be personally by someone acting on the direction of in the presence of the record of the transcribe of the testimony of the witness as required by the rules, signing with the when the testimony of the fully transcribed the otherwise recorded of the deposition should be submitted to the witness and the examination should be read to him or by him unless such examination by the reading of the waive of the witness of the parties any change of the form of the substance which the witness desired to make with the should enter the palm of the deposition of the officer within the statement of the reason given with the witness making them the witness shall take with the deposition unless the party with the stipulation waive the signing with the witness is ill or cannot be found with the refuse to sign with the deposition is not signed by the witness within 15 days of the submission of the to whom the officer shall sign it and state on the record of the fact of the waiver of the illness of absence of the witness of the fact of the refusal of assignment together the reason anything of the given thereof deposition may then be used fully as those signed unless the motion of the suppressed is found that the reason given the refusal to sign of the required rejection of the deposition of whole and part. The attestation. The officer certain of the deposition of the witness if duly sworn by him of the deposition true record of the testimony given the witness that the officer will not relatively employ with the representative of the counsel with any of the parties. 2. The not a relative of the employee for the representative of the counsel. And 3. Not a financial intern is just interested in the proceeding. H. Return. The official will securely with the seal of the deposition involving the endorsing of the sufficient information for the identified of the proceeding mark of the deposition here and the enter for the name of the witness shall enter the either personally with delivered promptly sending with original and one copy of the exhibit by registered mail to the officer of the proceeding of the deposition to be offered in the evidence must reach to the board no later than 5 days before the day of is to be offered. All right, notes of the party shall be taken in the deposition, shall be given the prompt notes over the filing of the other parties' copy with the use of the payment of the reasonable charge for the officers whom the deposition taken in furnish of the copy of the interested party of the dependent. 11-14-25. The errors over the effective of the errors and irregularities in the deposition. If the disqualification officer for the object for the taking of the deposition become the disqualification over the officer before them whom the taken to be taken is waived and left made before taking of the deposition begin to assume thereafter as the disqualification becomes known if it could be discovered with reasonable diligency. As taken of the deposition of the objection of the competency of the witness of the other competency relevance of the material of the testimony are not waived with the failure to make the exam before during the taking of the deposition left the ground with the objection of the one that might have been obviated with the move of the president at the time. The errors of the irregularities occurring with the oral examination of the man with the taking of the deposition in the form of the question with the answer for the oath and with the affirmation or in the conduct of the party of the errors and any of the kind that might be obviated removed that occurred impromptly at present with the minute where they waived and left the reasonable objection thereto is made for the taking of the deposition. Part C is completion of the return of the deposition objection to the errors of the irregularities in the manner in which the testimony transcribed of the deposition prepared signed with a certified with a seal with the endorsed and transmitted file with the otherwise dealt with within the officer of the under 11-14-23 and 11-14-24 with the waive of the left of the motion with the express of the deposition some part of the error of is made within reasonable promptness after such of the fact or otherwise due diligence it might have been ascertained. Or 11-14-26 with written irregular interrogatories to the party. The availability procedure for the use of the subject for the provision 11-14-21A. The aim of the party may serve for the aim of the other with the party with the written interrogatories to be answered for the party serve for the or if the party is served in the public or private the corporation partnership association governmental agency other than this board with the instance of the board itself with the party with the proceeding by any such officer or agent with the shall furnish for the information with the available the party with the interrogatory shall be answered with the separately with the fully written unless it has been objected to written which event is reasonable the objection should be stated with the lieu of an answer the answer to and be signed by the person making them or subscribed by any of the appropriate verification generally with the form of the prescribed 11-12-9 rejections are to be dispersed signed the representative of the council making the person upon them and interrogatories have been served with the shall serve with the copy of the answer for the objection to the time of the period is designed designated with the party submitting with the interrogatories, but not less than 15 days after the service of thereof. Option to produce the business record whether the answer interrogatory may be derived from the business record of the party with whom the interrogatory has been served from the examination of the audit, the inspection of the business record of the other compilation of the abstract with the summary based thereon, with the burden of the derived the assertion of the answer with the substantial the strength of the party with the serving the interrogatory as far as the party served insufficient answer for the interrogatory of the specific record from which the answer would have been derived with a certain video afford with the party with the serving of the interrogatory responsible opportunity to examine the audit, inspect such records and to the make of the copy of the compilation of the abstract summary thereof. Information softly is contained with the computer runs with the punch card, the tape of the which have the contained with the privilege, priority information with the information for the disclosure which is prescribed by the act, and the insufficient response under these rules, person whom the interrogatory have been served with the dwelling of the baby available to the person permanent with the independent with the professional organization with the not interested with the proceeding with the paid with the party with the serving of the interrogatory extract such with the run punch cards and tapes and information itself of the interrogatory that is not privileged to proprietary information with the information disclosure with which is prescribed at the act. Serve the interrogatories of the proceeding not requiring a position, no written interrogatory shall be served within 20 days prior to the day of the assignment with the commencement with the hearing with the filing of the opening statement, and in fact with the argument modified with the procedure with the written with the interrogatory with it be served with a foreign country with it shall not be served within 40 days prior to such date. Limitation on simplified standards in case of the within 3 benchmark method, each for the parties limited to 10 interrogatories, including subparts that may be absent advance authorization from the board. Art 11.14.27, the request of the mission. The availability procedure for the use of the subject of provision 11.14.21a, the party may serve the plan with any of the part of the written request of the mission for the purpose of the pending of the procedure, only with the truth of any of the matter within the scope of 11.14.21, set for the worth and the request including with the genuineness of any of the documents described with the request of the missions of the copies of the documents should be served with the request upon unless they have been made or otherwise furnished with the made available the inspection copy with each of the matter within the mission. The request of the should be separately established for the material admitted unless the width of the period is designated with the request, not less than 15 days of the service thereof of the party with whom the request is directed. Service upon the party with the requesting of the mission with the answer objection to the material matter signed by the party with his representative of the council objection. May the reason that therefore should be stated the answer should be specifically denied with the part of the set forth in the detail of the reason with the answering of the part of the cannot through truthfully admit with the denial of the manner of the denial should fairly meet the substance of the request of the mission with the good faith that requires that the party qualify with his or her answer with the denial only with the part of the manner of the admission was required that he specifies solely such of the truth of the qualified with the deny the remainder answering with the party with the not given the lack of the information knowledge of the reason of failure admit with the deny only with the he states or she made reasonably inquire with the information known with the readily obtainable by him and sufficient to enable him all and admit the deny of the party with the consider the manner with which the admission have them requested present with the genuine issue within the hearing may not on the ground alone object to the request of the he may subject to the provision 11.14.31 deny the manner set forth in reason that he cannot admit or deny. Effect of the omissions. Any matter of the admitted with these rules conclusively established unless the upon position showing with the good call of the board enter the order permitting the withdrawal of the amendment of the admission with the admission that made me at the part under this rule with the purpose of the pending of the proceeding only or is not an admission made by him or for any other person of the north made it be under used against him any other proceeding. Serve the written request for the admission with these proceeding requiring with the petition or request of the admission should be served within 20 days prior to the day of the sign of the commencement, hearing of the filing and opening of the statements of the fact of the argument one time with the modified procedure with the request of the admission is to be served with the foreign country should not be served within 40 days of such a date. Or 11.14.28, the deposition request of the admission of the written interrogatory to respond thereto with the inclusion of the record of the oral hearing upon the submission of the statement under the modification proceed with the deposition of the request of the admission written interrogatories and interrogatories respective response may be offered to the evidence of the party with the instant of the word taken the not offered with the part of the may be offered with the whole of the part and any other party if only with the deposition with the request of the admission written in the interrogatory with the response thereof that is offered to the evidence part of the other any other party with the manner of the being heard orally may require him to introduce all of it with the relevant part of the introducing any part of the introducing any of their parts of the deposition request for the admission written in interrogatories in response thereto that should be admissible with the evidence for the subject of the objections and subcompetency with the witness for the competency relevancy material of the testimony as witness noted at the time of their taking and made at the time of their offered of the evidence. 11-14-29. Supplementation of the response of the party with the respond with the request for the discovery, the respond with the complete, with the made, with the under, with the duly, due with the supplement of the proposed response, include with the information thereof, with the required with the following instance of the party, due with the duly, duty of the seasonally supplement with the respond with the respect of any of the question directly addressed to it. Identify the location of the person having the knowledge of the discoverable manner, with identify each of the person expected to call the expert witness for this, a hearing of the subject matter of the which he is expected to testify the substance of the testimony. Party who knows the later learns of the response with the incorrect honor of the duly seasonally to correct with his response. The duly supplemental response may be imposed in order to agreement of the parties anytime prior to hearing or submission of the verified statement of the under the modified procedure through the new request of the supplementation prior response. 11-14-30. The production of the documentation records of the entry upon land of the land for inspection and other purposes of the scope of the of the part of the nature of the other part of the request to produce the permit of the part of the make with the request of the inspect with the designate of the documents include the writing, the drawings, graph charts, photograph, phonograph, records, tape with the records, tape and other data that's complementations from with the information can be obtained with the translator, if necessary, without use of the detection of the device in a reasonably unusable form. Inspect the copy of the test of the sample of the tangible things which are in possession of the custody of the control of the party of them whom the record of the serve of the writings of the dab of the complications include the privilege and priority information of the disclosure which is prescribed by the act of the writing of the dab complication need not to be produced under this rule of the may be provided with the pursuant 11-14-26b with this part. To remember the subject with the property with the liability relief the safety of the operating of the consideration entry of the designated land or other priority possession with the control of the party upon with the request of the serve for the purpose of the inspecting the measuring the serve for the weighing photographing of the testing of the sampling of the property with the designated objection and opportunity thereof. Procedure. Any request filed with the presumed of the rule should set forth the item of the inspection of the individual item of the category, describe each of the item category with a reasonable particularity with the request should be specifically reasonable time of the place for the manner of the making the inspection performing the related acts. Limitation under the specified simplified standards indicate the use of the three benchmark method, each limited to the documentation required, including subparts the absence of evidence of the authority from the board. Agreements over the containing the interchange of the commitment to any proceeding involving the reasonable provision of the related with the existing rail carrier sale lease agreement, the serve of the introduce of the party with the agreement to the interchange of the traffic given the other party with the agreement rather than third party with the connecting carrier, whether the outright the prohibition per pay or car penalty, adjustment of the purchase price of the relatively rental positive the economic increment, other means of the party with the proceeding with the need the information made with the obtainment of the confidential complete with the version of the agreement prior to the approval of the board parties. Seeking with the strife of the approval must file with the appropriate with the motion containing the explanation of the party need for the information for the draft projected with the order with the undertaker that will ensure the agreement of the confidential the motion seeking the approval that might be filed and any of the time of the matter initial complaint with over the petition, including the before and answer for the compilation complaint over the petition is due with over the reply such for the motion must be filed within 5 days thereafter the motion will be considered by the board in any expedited manner. 11-14-31. Failure to respond to discovery. Failure to answer. The dependent of the failure to answer for the given evasive answer for the incomplete answer for the question propounded within 11-14-24a and the party that failed to answer for the given the evasive and incomplete answer for the written interrogatories serve for the pursuant 11-14-26a of the party seeking for the discovery must apply with in order to comply with the answer by the motion filed with the board and served only of all the party of the depositions deponents. Such motion that comply with the answer but must be filed with the board of the serve all of the party of the deponents and such for the motion component the answer must be filed with the board within 10 days after the obtainment of the response of the answer for the upon the deposition within 10 days after the expiration of the board of the allowed the submission answer for the interrogatories on matters relating to the depositions of the oral or examination of the proponent of the question may be complete with the adjourning of the examination before he applied within an order to reply with the motion with the play with the generally with expect with the Marie with the case of the conservative under the standalone cuff of the methodology with the simplified standard of the time of the filing with the reply with the motion comply with the is governed by the Title 49 CFR 110413. Alright, motion is compelled with a standalone with the cost of the simplified standard of the rate of the case of the motion. If it's compelled with a standalone cost of the simplified standard of the rate of the case, it include with the certification of that moment of it has gave with the good faith of the confirmed with the intent of the confirmed with the person, part of failing to answer for the discovery, the obtainment without the board intervention. In the rate of the case of the under the standalone cost of the simplified standard of the methodology, ever the reply with the motion to compel with the must be filed within the board within 10 days of the with motion with the compelled is filed. The conference with the party to motion with the compelled with within 5 business days after the filing with a reply with the motion with the compel with the rate of the case for the concern under the standalone copy of the methodology under the simplified chain of the board's staff may convey with the conference with the party that discover the dispute with the attempt to narrow the issue with the gather the of the further information needed to render the ruling. For ruling on the motion for the compel the stand of the loan conference simplified standard rate within 5 business days after the conference of the parties committee with the paragraph A3 of the section of the discovery director officer for the proceeding with the issue with the summary ruling on the motion to compel the discovery if the non-conference of the conveying with the director of the office of proceedings will issue the summary ruling within 10 days after the filing after of the reply to the motion to compel. Appeal for the director's ruling the procedures of the Title 49 CFR 11-15-9 and the board will attempt to rule with such appeal within 20 days after the filing of the repeal to the appeal. Reply to the appeal. Failure to comply with the order if the party with the other witness refuses to sworn, refuses to answer for any of the question after being directed to or do so by the board, will refusal may subject the refusing party or any person to action with the board of Title 49 U.S. Standard Code 1321 and C to compel the appearance of the compliance of the board order that any part of the officer of the director of the managing agent with the employee with the party with the person refuses to obey with the order of the made on the paragraph A with the section with the requirement of his answer the designated of the question and order made with them under 11.14.30 requiring them to produce any of the document or other thing and in court inspection copying with the test and sampling with the photographing of the permit and some of the permit entry with upon the land and other property of the board make in such orders in regard with the refusal of the justice and among others the following in order to the matter of the regarding with the question of the who asked with the character, the description of the thing of the land, of the contents of the paper, any of the designated facts should be taken within established by the purpose of the proceeding in accordance with the claim of the party over the obtaining of the orders refusing allow with the disobedient party with the support and oppose the designated claim of the defense of the prohibiting him of the introducing evidence of the designated documents of the things of the items of the testimony. In order to strike the proceedings of the part of there of the trading further with the procedures with the orders of abating the dismissing the proceeding of any of the party thereof, in lieu of any of the foregoing other orders of additional thereto, the board shall require the party failing to obey the order of the attorney advising party or both of the parties the reasonably expense with including attorney fee of the cause of the failure, unless the board find for the failure with the substantial justified with the other circumstance of the making an award or an expense unjust. Alright, C. Expense with the refusal to admit if the party after being served with the request of the Title 11.14.27 with the genuineness of the document with the truth of the matter of facts served with the sworn denial thereof the party requesting the admission thereof the proof of the genuineness any such of the document or their proof that in such a manner in fact that the board may order the party to make such denial to pay in such or any other party the reasonable expense incurred by making the proof and including the reasonable attorney's fee. Failure of the party to attend the service of the answer of the party of the person of the officer of the director of the managing agent of the employee of the party of the person willfully failed to appear before the officer with and take the deposition after being in the serve of the proper notice and failed to serve the answer of the integratory subject of the native with 11.14.26 with after the proper service with the integratory of the board of the motion notice of the made the strike without all the name of the party of the pleading party of the person dismissed of the proceedings and any of the part thereof in lieu of the answer of the order additional thereof the board shall require the party failing to act with the attorney advising of the board party with the both pay the reasonable expense with including the attorneys and cause of the failure unless the board finds the failure with the substantial justified any of the other circumstances making an award with expense of the unjust. Alright, E. Expense with against the United States, except expense for the attorney fees are not to be imposed upon the United States under this rule. 11.4.15 appellated procedures.